6. Furthermore, the respondent state deposited the declaration prescribed under Article 34(6) of the Protocol on 29 March 2010. Subject of the application. Fact of the matter. The record before the court indicates that on 11 July 2010, at around 4 p.m. at time, number 24 found guilty and sentenced on 4 August 2010 to 30 years imprisonment and 12 strokes of the cane for the rape of years. The applicant filed in case number 23/2011 against the judgment before the High Court of Tanzania at Bukoba, contesting the credibility of the prosecution witnesses, the consistency of the testimonies, and the administration of the corporal punishment, but the appeal was dismissed on 29 May 2014. Aggrieved by the High Court's decision to dismiss his appeal, the applicant lodged an appeal before the Court of Appeal of Tanzania at Bukoba in criminal appeal number 225/2014, which was dismissed. The appeal on 24 February 2015 as baseless. Alleged violation. The applicant alleges that he was deprived of his fundamental right to have his court heard in a court of law in violation of Section 2314 of the Tanzania Criminal Procedure Act, revised edition 2002, and Article 71C of the Charter. The applicant further alleges that Section 1302E and Section 1312E of the Tanzanian Penal Code, as in Article 2.5 of the Constitution 19. In his replication, Wally his right also alleges the violation of his right to legal aid. Prayers of the parties. The applicant prays the court to admit his application and review all the proceedings in the respondent state's court, including the issue of constitutional petition raised in the application. Wash and all becomes in Article 2. The state to hear rules. The state declared its right to see. This is declared that reject application that the court to be borne by the applicant. In his reply, the applicant already this to the of the extension of the merit rule 9 rule limitation is object this is the to as and that it here matter. Other jurisdiction. The court notes that its personal, temporal, and territorial jurisdiction has not been contested by the respondent state, and nothing in pleadings indicates that the court does not have jurisdiction. The court declares that it has jurisdiction to hear the case in view of the following. Admissibility of application. Terms of the protocol which show on admissibility of this taking into account provision of Article 56 of the condition of admissibility in contention The respondent is injection failure to identify of the unruled of the rules. The court overrules the objection, this objection to admissibility of the application. Objection based on the ground within a resolution. This objection to be application was not within a reasonable time. Merits. Alleged violation of the right to a fair trial. The applicant alleges that the applicant alleges the violations of his right to a fair trial, namely the failure to hear his witnesses, the fact that the conviction was based on insufficient evidence and conflicting statements of the prosecution witnesses, and the lack of access to legal aid. Allegation that defense witnesses were not heard. The court also has violated applicant's rights to defense under Article of the Charter by failing to ensure the appearance of his witnesses. Allegation to insufficient evidence and inconsistencies in witness statements. The court considers that the applicant's rights to a fair trial provided for in Article 7 of the Charter has been violated as victims and prosecution witnesses and the Council of clarified. Violation of legal aid. Article of Justice right is heard. This comprises the right to defense, including the right to be defended by counsel of his choice. The court observes that even though Article 7.1c of the Charter guarantees the right to defense, including the right to be assisted by counsel of one's choice, the Charter does not expressly provide for the right to freely assistance. However, in the matter of the United Republic of Tanzania, this court stated that free legal aid is a right interesting to the right to a fair trial, particularly the right to defense granted by Article 7.1c of the Charter. In its previous jurisprudence, the court also had with a criminal article entitled the right to legal aid, without having recorded the interest required, and particular if and if the penalty provided by the law is severe. In the instant case, it is not in dispute that the applicant was not afforded free legal aid throughout his trial. Given that the applicant was convicted of a serious crime, that rape, of 30 years, no free aid where did not have contingent, nor that it argue that he was financially capable of getting a legal counsel. In these circumstances, it is evident that the applicant should have been afforded free legal aid. The fact that he did not request for it does not exonerate the respondent state from its responsibility to offer free legal aid. As regards the allegation of the respondent state relating to the margin of discretion, that should be available to states in the implementation of the right to legal aid. Its not absolute nature and the lack of financial capacity. The court is of the opinion that the allegations are no longer relevant in this case, given that the conditions for the mandatory provision of legal aid have all been met. Accordingly, the court holds that the respondent state has violated Article 1C of Charter. The alleged violation of Article and of the Constitution of Tanzania. The court observes that it is not mandated the constitutionality of the national. This from meaning that particular position with national rights established the charter and any national human rights instrument certified respondent state. In the extent the applicant alleges that Section 132 and 131 Articles 82.5 of the Tanzania Constitution with to equality and equal protection of all, essentially in the same as three of the Charter. Incumbent up to 10 such sections of both Article Charter. Quote, every individual should be equal before the law and the right to equal protection of the not section 130 and 131(2)(e) of the Penal Code define the scope of the offense with the penalty. The code from the Penal Code and this in addition procedure. First, of the Constitution is general election which remain proven. In this vein, the court recalls its established jurisprudence that general statement to the effect that has been violated of more substantiation. In view of the foregoing, the court holds that the respondent has violated the applicant's right to equality and equal protection law under Article 3 of the Charter. The applicant prayed to respond to he released such as appropriate. In response, the respondent praised the court to dismiss the application and applicant's prayer entirely unfounded. Article 27 of the protocol states, and if the court that be of a human right, it should approve the violation including of reparation. Rule 63 of rules provides that the court shall rule request reparation by the same of or if circumstances require a separate decision. The court notes finding in paragraphs 7, 8, and 87 above that the respondent state violated the applicant's fair trial due to 1. The fact that not afford is witnesses were not heard, and that his conviction was based on insufficient evidence and contradictory statements of the prosecution witnesses. In this regard, the court recalls its position on state responsibility in Reverend Christopher Mitikila versus United Republic of Tanzania, that any violation of international obligation that has entailed the prohibition to prosecute report. As regards the applicant's conviction and sentence, the order is reiterates that not in a court for the reason that it does not operate within the same judicial system as national courts, and that it does not apply the same law as the Tanzanian national courts, that is, Tanzanian law. The court also recalls its decision in Alex Toma versus United Republic of Tanzania, where it stated that an order for the applicant's release can be made only under very specific or compelling circumstances. This would be the case, for example, if an applicant sufficiently demonstrates or the court itself establishes from its finding that the applicant's arrest or conviction is based entirely on arbitrary considerations, and his continued imprisonment would occasion a miscarriage of justice. In such circumstances, the release regard to refer to the of the Court of Human Rights and the Inter-American Court of Human Rights. In their case law, both courts, considering the nature of the violations established and in order to assist states to comply with their human rights obligations, have exceptionally requested respondent states to ensure the release of individuals with respect to some specific violations where no other options are available to remedy or to put an end to the violations. The instant case quoted that the violation to Article 7 Charter by failing to have him denied his witnesses heard, conflict in states of the witnesses. The court considers in of the fact that it has violations of the request for the and taking into account the nature and scope of the violations and the offense can in this instant case order the respondent to release the applicant from prison. In order to ensure fair and adequate reparations for the violations, the court finds the violation affected the right to a fair trial guaranteed in the Charter. Consequently, the trial of the applicant be reopened, taking into consideration the guarantee of a fair trial pursuant to the Charter and international human rights standards, including the defense. The court, lastly, that parties did not request of prohibition of reparation. The respondent praised the court to rule that the cost be borne by the applicant. The applicant has made a specific request on this issue in terms of Rule 30 of the decided the court each should bear its. In the instant case, the court decides that it should bear costs. Firstly, on jurisdiction. 1. This is the object to jurisdiction of court. Declares that on admissibility. Dismisses the objection to the admissibility of the application. Declares the application that the application is admissible. On the merits, finds that the alleged violation of applicants' right to equal protection before the law provided for in Article 3 of the Charter, the content of which is similar to Article 32 and 5 of the Tanzanian Constitution, has not been established. Finds that the respondent state has violated Article 7(1)(c) of the Charter by failing to provide the applicant with legal aid. Finds that the respondent state has violated Article 7(1)(c) of the Charter by failing to hear the applicant's defense witnesses. Finds that the respondent state has violated Article 7 of the Charter by convicting the applicant on the basis of insufficient evidence and contradictory statements of the prosecution witnesses. Dismisses the applicant's prayer for the court to squash eviction sentence. Dismisses the applicant's prayer for the court to directly order his release prison state to read the case within 6 months in conflict with the guarantees of a fair trial pursuant to the Charter and other international human rights instruments, to conclude within time in 2 years from the date of notification of this judgment. Orders on state to report on the notification of 2 years the notification of judgment. First, each party shall be its own host. Done at Arusha, 21st day of November in the year 2000. In English, the English version being authoritative. We are now going to deliver the judgment in the matter of Anaclet, Paulo versus United Republic of Tanzania. The judgment will be read by the Vice President, Honorable Justice Ben Kyoko.
Matus, Susan Meng, Teresa, Ann Chizumira, Africa Bendaula, and Stella judges and Robert N. Registrar. In accordance with that code of the African Charter on Human and People's establishment of the African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 82 of the Rules of Tanzania did not the application. The Anaclet Paulo is a citizen of Tanzania filed having as term at the prison in the State Republic of Tanzania, which became part of the African Charter on Human and People's Rights, after that was the Charter on 25/6. and protocol to African Charter human rights, establishment of African people's rights, and declaration prescribed for protocol 29 March 10. Sub the application of the matter. File code before Belgium or Ingo later and his wife, they made away with a sum of 800,000 Tanzanian shillings, a radio cassette player, 5 trousers, 2 wristwatches, and 3 pairs of loin cloth. On the same night, the applicant and 3 other individuals were arrested by the police and charged with the offense of armed robbery with violence. By a judgment of the Muleba District Court delivered on 27 November 1997, 3 of the accused, including the applicant, were found guilty and each sentenced to a term of 30 years imprisonment. The applicant lodged an appeal before the High Court of Mwanza, and on 6 June 2003, the High Court held a public hearing in the absence of the applicant and without the original case file. In a 17 June 2003, the Court the appeal and upheld the judge's district court. The applicant was notified on 4 February 2005. On 2 February the same day, the applicant filed and the Court of Appeal sitting in January 2006. Appeal notified that never on 27 to accused of time high appeal before on 29 September 2009 dismissed the request for extension of time on the basis of the grounds in court for seeking extension relevant and that for appeal belongs dissatisfied their application of time appeal on 8 November 2009. The applicant is co-accused the matter before the criminal 120 appeal dismissed by the appeal instrument 5 August 2003 as violation. The applicant alleges that he was denied bail pending his trial, and this he claims is unjust and in contravention of the Tanzanian Constitution and its right to personal freedom, equality before the law, and equal protection of the law as guaranteed by the African Charter on Human and People's Rights. His conviction and sentence to 30 years in prison was based on a crime which did not exist at the time of the Number 3, not afforded to be as he was not at the High Court. 4, the proceedings before the High Court and the Court of Appeal were flawed because they were conducted without the original record of proceedings in criminal case number 123 of 1997 before the District Court. 5, he had the right for the High Court of contract to see the party. The court is the violation of the Constitution and is right by the court of the state. 2, granting reparations pursuant to Article 27(1) of the Protocol and Rule 34(5) of the rules. 3, issue such other orders or reliefs as it deems necessary based on the circumstances of the case. 4, facilitate the access to legal aid pursuant to Article 10(2) of the Protocol and Rule 31 of the rules. Declare that it has jurisdiction to hear the matter. Declare that its application is well-founded, and call on the respondent state to bear the cost. In its response, the state court declared that it lacks jurisdiction to hear the matter. that the admissibility out 40, 45 and 6 of the rules of dismissal said application. Find that a state not right and 232 Article 1 and C and Article 7.2 of the Charter. 4, declare the application is unfounded. 5, dismiss the applicant's prayer for repentance. And 6, order the applicant to bear the cost. Jurisdiction. In Rule 9 of the court shall bear the examination of the administrative applicant. On this matter, the court dismisses the respondent state's objection and finds that it has material jurisdiction to hear the case. On other aspects of jurisdiction, the court notes that the personal, temporal, and territorial aspects of jurisdiction have not been challenged by the respondent state. Furthermore, there is nothing in the record indicating that it lacks personal, temporal, and territorial jurisdiction. The court therefore finds that it has personal jurisdiction, it has temporal jurisdiction, and its holds some sort of to the code of administrative account of data. With regard to the misapplication, responses to the of exhaustion remedies and for the based source court that in this respondent objection admissibility exhaust remedies. Object based on reasonable time. Due question, the court dismissed the state's in a of fire within conditions of admissibility not in contention in the examining this particular or its conclusion meets all the conditions contemplated in Article 56 of the Charter and Rule 40 consequently clear and alleges that it is right and to trial. With regard to the in because you to 6 Article 8 Article 9 and violation to liberty. After demanding requested ending his trial was denied. He condensed that denying him a violation of his right to freedom is guaranteed by Article 13 and 15 of the Constitution and Article 6 of the Charter. The court noted limits to freedom mentioned in 6 of the Charter, particularly arrest or detention, are exceptions to Charter subject to legality. Instant the court denial of bail is provided by law whether it's justified by legitimate reasons and whether the restriction is proportional. On this issue, the court noted that Article 52 of the Tanzania Constitution provides 2 situations where limits to freedom may be placed, where the person is under the execution of a judgment, an order of sentence given or by the court, following addition in circumstances in process reference in it provide for 5 and 1 security, protect the rights of others, and to avoid possible repetition of the offense so far as this provision covers cases of armed robbery. The restriction is further justified by the need for the appearance of the accused for the purposes of administration of justice. The court goes on to conclude that the applicant's detention pending trial was not without reasonable grounds, and so to grant him bail constitute a violation of his right to liberty. The Constitution are therefore not violated. Alleged of the right to protection of the law and before the law, that that the distant fundamental law in this matter, the situation was similar as was even the state violated for the and protect law. Right to defense. The operator is that the country was called because that title party now proceed and to adduce his evidence with the where the indices not proceed that he not take in this regard. The court for courts sense of any would the court the charter defending the right vested by one's they not clearly provide the right to free legal. The court, however, calls that its jurisdiction to which is a right and that when the interests of justice so require, a criminal offense must be of his right of instance, or if it's indigent or offense is serious, and the penalty provided by severe. The instance there was accused of offense punishment by a sentence of 30 years, and it was in the interest of justice to provide him with free legal aid. This was made even more necessary by the fact that the applicant claimed paid of assault. The other note at in provided with free legal, the respondent state does not the fact that it was indigent. The conclude that by to do so for 71C of the charter. The allegation that here is not provided by this notes that the affirms having taken note of the observations on this argument in its further it has noted Tanzania the minimum sentence for armed robbery with 30 men the 1994 law. The court therefore finds that the respondent state did not violate Article 7.2 of the Charter, and that the applicant's conviction and sentence to 30 years imprisonment was in accordance with the law. Reparations. As stated in paragraph 18 of this judgment, the applicant prays the court to grant him adequate reparation pursuant to Article 27 of the protocol. And 2, order the respondent state to bear the cost. 3, issue such other orders or measures as the court deems appropriate in the circumstances of the instance. When we clarify and substitute for it, the act did not any on the state is submit pray that to dismantle and guide him to the cost. One of the court finds that the violation of rights, the violation or Rule 63 of the rule states that a rule on the request for reparation by the same decision establishing the violation of a human and people's rights or the circumstances so required by separate decision. The court recalls its jurisprudence in Christopher Mutikila versus United Republic of Tanzania, where it found that any violation of obligation to provide report. Notice and capital this outcome of trial. The court this to the applicant who requested adequate compensation in Article 7.1 of the protocol. The court therefore in Tanzanian shilling in 30 by the shall bear its own cost. The that the praise their on even though they did the amount to order the cost. This and that there for this one the objections clear that has jurisdiction on and clear on the merits unanimously declares that the respondent state did not violate the applicant's right to freedom as provided under Article 6 of the Charter. 2, declares that the respondent state did not violate Articles 2, 3, 1, and 2 of the Charter on non-discrimination, equality before the law, and equal protection of the law. 3, finds that the respondent state did not violate the applicant's right to have his cause heard as provided under Article 7.1 of the Charter. 4, declares that the 30 years prison sentence is in accordance with the law and is not in violation of Article 7.2 of the Charter. 5, declares that the respondent state violated the applicant's right to defend and see for to free legal assistance. Award the applicant an amount of 300,000 Tanzanian shillings as fair compensation. 7, orders the respondent state to pay the applicant the said sum and report to the court within 6 months from the date of notification of this judgment. And 8, orders the respondent state to pay the cost. Done at Arusha on this 21st day of September in the year 2018 in English and French, the English text being audited.
Also decide. The judgment versus United Republic Tanzania, read by Justice in the matter of Minani Evarist versus Republic of Tanzania, application 027/2015. The court, composed of the same judges as in the two judgments just delivered, after the delivered the judge, the Minani, national of the Republic of Tanzania, currently serving a 30 years prison term of the crime of rape at Butimba Central Prison in Mwanza. The respondent state is the United application